Hello, everyone. Welcome. All right. People are coming in. We're going to wait just another couple minutes. You are definitely in the right place. Today, we are talking about practical strategies for ethical language access advocacy. And we're genuinely glad you're here. Whether you're just made yourself a coffee or are eating lunch at your desk or heroically joined from the car, we see you and we're happy you made it. Before we get going, let's do what we always love to do. Drop in the chat where you're connecting from. We have participants from all over, and it never gets old to see just how far this community reaches. My name is Liliana, and I'm the manager for content and curriculum development at Cross Cultural Communications. I'm joined today by my colleague Naisel, our program manager, and she will be keeping an eye on the chat, dropping in helpful links, and making sure everything runs smoothly behind the scenes. Basically, she's the person making me look organized. Thanks, Nicel. To see the ASL interpretation, click on Interpretation and select American Sign Language. Thank you to our ASL interpreters today, Jenna and Madison. We are super grateful for your work. And a few quick announcements before we bring in our presenter. A friendly reminder that CCC runs on Easter time. So if you're on the West Coast and this felt early, you have our sympathy, full on. So our bilingual English-Spanish educational interpreting glossary, very comprehensive, is almost here. Weeks of work, hundreds of terms built specially for educational interpreters, bilingual school staff, and liaisons. We're not quite ready to release it yet, but there will be a link in your chat. You can sign up on the link in order to be the first one to know when it comes out. If you'd like to step into legal settings with confidence instead of panic, Carola Lemaha Richer, federally certified court interpreter, 15 plus years of experience, is teaching Introduction to Legal Interpreting on May 5th and May 7th. 2 evenings, fully hands-on. You can register by April 24th and save $35. Link is in the chat. And if you have ever thought about becoming a licensed trainer, this summer is your moment. Our TCII training of trainers, our TOT, runs July 13th through 31st, Mondays, Wednesdays, and Fridays. It is one of the best things you can do for your career, and the people you will meet make it worth every minute. Also, link is in the chat. All right, announcements are done. Here's what today looks like. The presentation will run approximately 50 minutes, followed by a Q&A segment. Please use the Q&A feature, not the chat, to submit questions for our presenter, Mike. That way, nothing gets lost in the scroll. For general comments or questions about CCC, the chat is the right spot. Just make sure it's set to everyone if you'd like the room to see it. Now, the part that everyone came for, the CEUs. This webinar has been approved for 1 CCHI, 1 ATA, zero point 0.1 RID credits, and 0.1 IMIA and BCMI. The last one is pending, by the way. Within 48 hours, you'll receive an email with a link to download your certificate of attendance. Check your spam or junk folder. If it doesn't show up, certificates have a mysterious tendency to end up there. Certificates are available to live attendees only and must be downloaded within 3 weeks before the link expires. And now, the part I have genuinely been looking forward to. We are so pleased to welcome today's presenter, Michael Mulé. Michael is an attorney with 20 years of experience advancing the rights of people who communicate in non-dominant languages. And if you follow language access at all, his name is probably not new to you. For 15 years, he led national Title VI and language access initiatives at the U.S. Department of Justice, spanning both the Civil Rights Division and the Office of Justice Programs. At the Civil Rights Division, he led the Language Access Courts team, filed the first language access statement of interest in a federal lawsuit, and administered lep.gov. Before his time at the DOJ, he worked to expand access to public services for low-income deaf and Spanish-speaking clients, because this has always been more than a legal exercise to him. In 2025, Michael received the Language Access Champion Award from the National Council on Interpreting in Healthcare. If you ask us, that award found the right person. He now consults on civil rights and language access for public and private entities, and we're genuinely fortunate that he's spending this hour with us today. Michael, thank you for being here, and the floor is yours.
Thank you, Liliana. I do appreciate it. And thank you for cross-cultural communication for hosting me today. I want to make sure that everyone has these, so I'm going to put them in the chat on my own. But there's a link to the slides in PDF. You don't have to take notes. And there's a link to a handout that references everything I'm going to talk about, so you don't have to take notes. Those are two links to the two PDFs. So let me share my slides. 1 second here, and I will get started. Share screen, slideshow. Okay. Want to make sure people can see that. I think you can. Okay. Today, we are going to talk about practical strategies for ethical language access advocacy. Okay, why does this matter? Why are we talking about this today? Well, there's a few reasons, and I'm going to cover these a little more in detail, but as you know, there's been a lot of confusion about changes that have happened over the last year or so. So we're going to talk about what protections remain, what happened, what protections remain. It also means that there's an opportunity for state and local advocacy because there's a lot of uncertainty about what is federal enforcement today. And the other thing I want to really spend a lot of time on, and I really want you to appreciate as interpreters, is that interpreters have a real unique expertise and insight about language barriers people encounter. And some of the most effective advocacy approaches I've seen are based on real stories that demonstrate the harm when people are denied access because of their language. So that's the why we're here today. Let me go over the roadmap of what we're going to cover today. So today there's 4 things I want to cover. And there is, like Liliana said, there is a question and answer part at the end. But today we're going to focus on 4 topics. Where is language access today? What are the opportunities for action? And they are opportunities for action. 2, the ethical considerations before you act, and how there are ethical opportunities to act and to engage in advocacy. 3, I want to cover specific advocacy actions and the potential risks of those advocacy actions, because I want to be honest about what could happen. And also there'll be 3 levels that I'll be talking about as far as risk. And lastly, again, back onto you as a professional, self-protection, actions and strategies, actions you can take and strategies you can engage in for self-protection when engaging in advocacy approaches. So, first topic, where are we today? I know a lot has happened. And in this part, I want to talk about, of course, Executive Order 14224, and I'll cover what that is if you don't know what I'm talking about. What did change? What did not change? And I'm going to talk about challenges and opportunities, changes in federal priorities, like I said earlier, and then also some confusion about the executive order, just so we have clarity on where are we today. So let's start on the first part, which is the executive order itself. So, Executive Order 14224, or EO 14224. What did it change? Well, first, what is this? This is an executive order that the president signed in March of last year, of 2025. And what did it say? Well, it directed federal agencies to act. And it made English the official language, but only for federal agencies in the executive branch. It did not and does not have the authority to make English the official language for the entire country, only for federal agencies in the executive branch. What did it also do? Well, it revoked an executive order from 2000 called an Executive Order 13166 and all guidance related to that executive order. But the last thing it did is also really important. It said to federal agencies, even though English is the official language for federal agencies, agencies can still provide materials in other languages. So it said, we're making English the official language of federal agencies, but you still can, federal agencies, provide those materials in other languages. I think people forget about that last part. What did it do? It directed federal agencies to revoke Executive Order 13166 guidance and for DOJ to issue new guidance. What you should take away is the Executive Order 14224 was only about what federal agencies in the executive branch need to do. So what did it not change? Well, it didn't change state or local entities' obligations, which means they still have to comply with all federal, state, and local civil rights laws and obligations. Why? An executive order does not have the legal authority to direct or change any laws or acts by Congress, a state government, or a local government. The executive order and any executive order does not have the authority to change Title VI of the Civil Rights Act or any other non-discrimination laws. And an executive order does not have any authority to change court decisions or if there are any local laws. So what does that mean? Well, the executive order only applies to executive agencies in the federal government, which are federal agencies, and it does not change laws that exist, which include civil rights laws like federal civil rights laws or the Americans with Disabilities Act. And it does not change state or local laws. It does not have the authority. An executive order, and you might get this from its name, can only direct action by the executive branch of the federal government. It can't tell federal courts what to do. It can't tell Congress what to do. It can't tell state and local governments what to do. It is limited only to federal agencies. So I know I spent a little time on that, but I think it's really important to understand the scope of what it covered and what it did not change. It did not change Title VI and other civil rights laws. And that's important for our conversation today to know what protections are left. So, what are the challenges and opportunities? Well, as you can tell from the executive order that I just described, language access enforcement is not currently a priority for federal agencies. And that may lead some people to believe that they no longer need to comply with civil rights laws. But remember what I just said, those civil rights laws did not change. So while there might be an executive order telling federal agencies what to do, every entity that's required to comply with federal civil rights laws still has to comply with those laws. So that's one thing, the change in federal priorities. There's also a lot of confusion about the scope and authority of Executive Order 14224. And because of that confusion, there have been actions over the last year by state and local entities to remove language access protections. Some of you might have seen this in your own state or local government. I want to give a couple examples where state and local entities have removed or scaled back language protections. The example I want to give because it's related to interpreters is in Wisconsin. So there was a bill proposed in the legislature to make English the official language and to allow artificial intelligence to take the place of human interpreters. This all happened this legislative session, so the one that's going on right now. What happened with that bill? Well, there was strong opposition from language professionals, including both interpreters. There was testimony by language professionals, and there was even advocacy letters sent by interpreter organizations and even some language companies saying that this is not the right approach. And what happens? Well, as of today, and I just checked this the other day, it seems very unlikely this bill will pass this legislative session. So Wisconsin is just one example of kind of how some states have responded to and have been confused about what the executive order was supposed to do. Another example in Florida, this one didn't get as much headlines, but Florida no longer translates driver's license exams as of February of this year based on a policy change. by the state DMV office. They have a state DMV agency, motor vehicles agency. It made a decision, I think, on in 1 week, and then the following week they said this change will be in effect. Some concerns have been raised about this by about this change in policy by civil rights and advocacy groups, but different than Wisconsin, this change is still in place. So I just want to give you some examples of what this confusion about Executive Order 14224, what are some examples of how states and local governments have responded to it. And while these challenges are not insignificant, and that type of legislation is particularly harmful to different language communities, there are many opportunities still available to educate people about where language access is today and to encourage them to improve policies and practices that will ensure compliance with federal civil rights laws. So there are challenges, but there are also opportunities, right? There isn't going to be as much federal enforcement, and there hasn't been from what I've seen over the last year. There has been some confusion, but I think that's because, which is why I spent so much time in that first part, people don't really understand what the executive order did, but also what it did not do. It did not change those civil rights laws. And so states and local governments have been taking actions because they misunderstand what the executive order did. But there are opportunities, which is what we're going to focus on today. There are some challenges, but there are opportunities for advocacy and action, which is a lot of what I'm going to spend my time on today. So, what are these opportunities for action advocacy, which is the second part we're going to cover right now? Well, there's 4 topics in this part. Before you act, right? Separating what advocacy actions can be taken during encounter and those that can be taken outside the encounter. There are clear ethical implications, right? So before you act, understanding the ethics of during an encounter versus outside the encounter. I'm going to provide you some examples of activities that will generally not cause ethical issues. And for each category, I'll talk about the risk associated with each one. And then after talking about the general categories of risk or exposure, I'll talk about how to identify issues, supporters, and how to have conversations with colleagues. And then I'll give you a few examples by sector. So in this part, I really want to talk about, and of course, start with before you act ethics, some examples, how to identify issues, and then I want to give you some specific examples by different types of sector. And by sector, I mean like health, legal settings, educational settings. All right, so let's get to the first piece of opportunities for advocacy, for action and advocacy. First, before you act ethics, right? Very important professionally, very important for professional interpreters. And when you look at national organizations that create ethical and professional standards for interpreters, they have addressed when advocacy is permitted both during and outside an encounter. And by an encounter, I mean that event or that time where an interpreter is providing their services for a particular entity, right? So that encounter when an individual has an interpreter there to communicate and to assist them in that encounter. So what I want to do right now is look at what I know there are other interpreter organizations, but I want to look at what 3 of these organizations have said. Again, all of these resources are on the handout, so you don't need to find these documents to read along. They're all linked on the resource document. The first is the National Council on Interpreters in Healthcare, or NCIHC, which has a guide that addresses advocacy, and a lot of you know, recently addressed advocacy in the draft standards, which are currently under review. So if you look at the 2020 guide, it explained how actions like clarification, management of the flow of communication, and cultural brokering are all ethical actions an interpreter can take during an encounter. I'll be making this distinction a lot, but during an encounter, NCIT talks about how those are all ethical actions that can be taken during an encounter. But I also want to talk about Principle 9 of the draft standards, the NCIHC draft standards, which explained very similarly how even though those are allowed and ethical, and I'm just going to quote here, it's extremely unlikely for an interpreter to need to advocate during interpreted encounters. right? So that's one of the things the draft standards said. But the draft standards also said at 9.1, so this is in Principle 9, but in 9.1, it said that interpreters may engage in advocacy during encounters, quote, in order to protect an individual when there's an objective and verifiable evidence of risk for serious, imminent, avoidable physical or emotional harm that remains unaddressed. So it's extremely unlikely, but there are moments where um, during an encounter, the interpreter does have the opportunity to advocate, and 9.1 talks about those. And then in 9.2, it says that, quote, interpreters may advocate outside interpreted encounters on behalf of a party or group to correct a pattern of mistreatment or abuse. So 9.1 talks about during the encounter, but 9.2 talks about outside of the encounter to address um, to address issues on behalf of a party or group. And I just want to focus on another thing that 9.2 has. I know these are not the formal standards. These are not the new standards yet. They're in draft, but I thought this was helpful. And if you look at 9.2 in the examples, it gave this example. It said, quote, interpreters may write to their legislative representatives, national, state, and local, in support of good language access policies. I think that's important because it reminds me of the Wisconsin example, where we did have interpreters writing about what would be good language access policy. And a lot of people said relying on artificial intelligence instead of human interpreters would not be good policy. So that's NCIHC. What have other people said? Well, when you look at NAJIT, National Association of Judicial Interpreters and Translators, they have an advocacy guide. I don't know if people have seen this that came out in 2017, and it explained that an interpreter must remain impartial during an interpreted encounter, but when in professional associations, interpreters are subject matter experts who promote the profession and its practitioners. And NAJIT also created an advocacy toolkit. So during the encounter, but when in professional associations, and interpreters are subject matter experts who can promote and do promote the profession and its practices. And the last one I wanted to mention was the American Association of Interpreters and Translators in Education, AAITE. Their code of ethics and standards explains that advocacy during an encounter, quote, is controversial. I think a lot of people know that, and we've already talked about that. And, and more often than not, prohibited in spoken language interpreter codes of ethics. But it also said that advocacy, quote, for the profession is highly encouraged. So again, when we read these three together, from NCIHC, from NAJIT, and from AAITE, what can we take away? And I have three things we could take away about advocacy. One, the advocacy actions an interpreter can take during an encounter are different from the actions they can take outside the encounter, right? Two, during an encounter, the need for advocacy is very unlikely, but it is permitted. But permitted ethical advocacy actions include things like clarification, management of flow of communication, cultural brokering, and protecting the individual. So we saw that in some of the standards I went through. And then lastly, and this is kind of important for our conversation today, interpreters can advocate outside of an encounter in professional settings or on behalf of a party or a group to correct a pattern of mistreatment or abuse or to support good language access policies. So even when we look at the current ethical standards and those draft standards, we see that there is this important distinction between actions that can be taken during the encounter and those that can be taken outside. So what are some, and I want to give some of these examples here because it seems kind of theoretical, right? What are some examples of activities that will generally not cause ethical issues? Let me just give you a few examples here. Speaking as an expert about language barriers and systems. Interpreters do that all the time. That's ethical. Providing training and education on these issues. I see that all the time. Interpreters do that. Advocating as private citizens with government representatives at all levels. I know there's a lot of advocacy done at the state and local level like that. And then engaging through professional associations on these issues. Right. These are all activities that are permitted and allowed and that people do today. And if you look on the resource handout, I put some examples, but not all the examples. There's many examples of advocacy efforts that interpreter associations and groups have engaged in over the years. Okay, so before you act ethics, of course, I'm going to cover that first. I know it's very important. I know there's a lot of interpreters that are going to send me, emails about why don't you cover ethics? We are covering ethics. It's very important. But ethics standards do not say there is no role for advocacy. There is a role, and we're going to talk about it in the context of specific actions. So let's walk through, and I want to walk this through generally now, and I'll go through it in more detail in a second. But outside of the encounter, and that's the key difference here, outside of the encounter, I wanted to give you kind of three general categories of ethical actions, but I want to give them to you by degree of personal risk or exposure, right? Because they do have some risk of exposure, right? Let's be honest at the outset. That is something that you're doing, right? You're speaking out, you're saying a thing, you're even working with a group. There is some exposure. So low risk, okay? Low risk individual actions include writing letters, reporting issues, especially if there's established reporting or complaint systems, and joining professional or advocacy groups. Very low risk. You can join advocacy groups, you can write letters, you can report issues. Moderate risk. These are more public actions, and they include things like testifying before a professional or government body, right? You could testify in opposition to a certain law or bill that's being proposed. Signing group letters, right? So and so interpreter group for state or regional organization of interpreters, signing on to that letter individually, or maybe you're just a member of the group. Training others, doing training people about their rights, training people about the profession, its role, the role of the interpreter. Those are all in the moderate category. Okay, what's this higher risk category? I know everyone's like, okay, those seem okay. What's this higher risk? What's escalated? This includes more legal actions. What do I mean by that? Administrative complaints. So if you file an administrative complaint with a state civil rights office, or maybe you filed a lawsuit, or you're part of a lawsuit that's filed on behalf of many individuals in your state, or it might be your own individual complaint or lawsuit. For example, the example I'm going to use here is retaliation. Say you filed a civil rights complaint, and the person you filed the complaint against finds out that you did. They know it's you. They know you filed the complaint somehow, and they took some kind of adverse action against you. It could be anything. Maybe they never call you to be an interpreter again. Maybe they kind of blacklist you, or maybe they threaten your credentials or to take them away. That could be a form of retaliation. So maybe you file a complaint with an administrative agency, or you file a lawsuit at the state or federal level where you allege retaliation because you engage in protected activities. I'm just covering these categories generally now. I'll be covering these in greater detail with practical examples in the next section, but I also put practical examples on the first page of the handout. I just don't want people to have to worry about taking every single note. I do want you to be able to kind of take this in, have the resource document for after the conversation. All right, so those are examples of, those are generally, let me go back to this, general categories and examples of action examples and categories of risk associated with each one. Next, how do you identify issues? This happens a lot, right? Like, okay, well, I do want to take action. Well, how do I identify what's going on? How would I identify an issue is happening? A lot of this comes, and I'll just say from my own experience, having worked with interpreters who have filed complaints or talking to interpreters over the years, there's a lot of ways to identify issues and supporters. Um, Talking to friends, family members, people in your community, they might share with you, oh, did you know, like, there's been a change in policy and we no longer get interpreters for this kind of thing, or the person that took over doesn't know what they're doing and they're denying these requests. Talking to your colleagues. A lot of interpreters I know have colleagues that they work with on a regular basis, or maybe they're part of, or maybe they see them at a meeting or at a conference and they talk about issues. That's how they identify issues. Hey, that's happening in your state or in your county. That's also happening over here. That might be a way to identify a bigger issue that needs to be addressed. Um, Meeting with organizations who work with these language groups. Some of you work with mean, your job and your primary work is working as an interpreter, and working in that professional setting, but you also might have associations you're part of or groups that you're a part of. And there might be language groups um, that you're part of that communicate, oh, I saw this issue, or like our group is seeing this issue. That's another way to identify issues. Um, some people, because of existing work or past relationship, they actually know community groups or civil rights groups or even state civil rights enforcement offices, and they identify issues from talking to those individuals. And a lot of people are part of, and this last example I want to give here is a lot of people are part of and join national or statewide groups. And one of the issues, that's not all the issues they work on, but one of the issues that a lot of interpreter associations and groups work on, because it's so closely related to their work, are language access issues, issues related to people getting access to different services and benefits. So those are all groups you can join. Those are all people you can talk to. Those are different ways to identify issues. And it doesn't mean that you have to go out alone. I know it's a lot, right? To identify an issue, have to write the letter yourself. That's not what I'm talking about here. I'm talking about, well, there might be a lot of commonality. You might have several colleagues that are experiencing the same thing. Collectively, or maybe under the umbrella of some interpreter group you're part of, you could write that letter and say, our members have raised this concern, or our members are part of these language communities and they're seeing this issue happen all the time. We need it to be addressed. Um, Collective action is really helpful because it gives different perspectives. It gives more examples of what is going on. So, how do you identify issues? Some ideas. I know a lot of you know these ideas, but I just want to lay it out. There's a lot of ways to come up with what are the issues that people are encountering? What are the issues that we could address? And then just a couple examples by sector. I picked medical, legal, and education. Medical, just an example here. Reporting that there's a repeated lack of interpreters in an emergency department, right? That's an example of kind of an advocacy action that maybe an interpreter group could take or a group of individuals could take to address an issue that they're seeing. Legal, commenting on a court interpreter rule change. If you look on the resource document, you'll see that recently Michigan proposed changing one of its court rules about access to interpreters, and there are comments there from interpreter associations about that court rule. Education, and a lot of people, have different responsibilities in different settings, but in the education setting, maybe it's advocating for translated materials for parents, right? Or advocating for improvements to how quickly those translations are processed. So just a few examples. I know there's lots of other examples that you probably have, and I'm sure we'll talk about that in the questions part. But just to give you a couple examples by different sectors, that there are a lot of activities you can engage in where you can address these issues. And a lot of them are, I know, repetitive, right? This person has this issue, whether at the hospital, whether they're in a legal setting or at a court setting, or whether they're in an educational setting. Um, but there are a lot of examples where not only people have identified the issues, but where interpreters and interpreter groups have taken action to address those issues. The third thing, and I know this is really what we wanted to get to as far as the specifics, I really want to talk about the specific actions and the risks. I know earlier I gave a preview of this, but in this section, I want to explore the three categories of ethical actions I presented earlier in more detail. I want to give you practical examples of each of these. And these examples are based on actions I have seen interpreters take over the last 20 years. I know there are people with more experience. I know, of course, there are interpreters that have many more examples that I'm providing. But like I said, links to these examples, I don't reference them all by name, but links to these and other examples are on the resource document. Now, I wanted to use the traffic light as a symbol today for our risk. Um, Although we're going to do it in reverse order, but we're going to start with the lowest risk, which is green, and work our way up to the higher risk action in red. I couldn't think of any other good visual representation to show kind of the green, the yellow, and then the elevated, escalated actions. So let's start with the bottom, which is green. And I've talked a little bit about this already, but what are the types of low risk individual actions? So what are these? These include things like individual advocacy letters or complaints. So these are letters or complaints that are sent either directly to the entity itself. So you would say, I'm going to pick on courts because I did a lot of courts work. You know, I'm a interpreter association for X county, and you send a letter to the court for the court system for your particular state, and you say, this is a complaint about how interpreters are not always provided in civil cases in our state, right? So the letter is directly to the entity itself. That letter or complaint could also be sent to a state attorney general's office. Some states have attorney general's office that do civil rights issues and that could address some of these issues. You might also be in a state where the state has a language access law or an equivalent at the state or local level. So there might be a state or local entity where you can file a complaint about, hey, this entity, this hospital or court or whatever, is not complying with the law that they're supposed to follow, and they're not providing language services. Um, so you could send it to the state attorney general's office or the state or local civil rights enforcement office. And because of recent policy changes that I noted earlier, it's not that I'm excluding federal agencies. You can file a complaint with federal agencies. I just want to be cautious and I want to manage expectations because it doesn't seem that at the federal civil rights level right now, there's a lot of enforcement on these language type issues. But there's a lot of work that has been done and that people are doing at the state and local level. All right, another category here, organizational or group letters or complaints. These are the letters from that interpreter group, either the national or the local group, sent to the entity itself. Again, sent to the attorney general or sent to the state civil rights enforcement office. These are all what I call low risk actions, right? You can do it as an individual, you can do it as part of an organization. And then the last part here, you can request changes to existing or recently changed policies that harm language communities. That is the moment where you can take action or engage in advocacy on those issues. The last one, so the third category here, requesting changes to policies. Maybe there was a recent change to policy. Maybe it's the Florida DMV policy, right? So you send a letter to that office or agency. You send a letter to the government attorney for that office or agency, or to the mayor or supervisor or council member that made that change in law or policy. The audience will be different, but the activity is very similar. And lastly here, because this does happen, sometimes there are opportunities to comment on proposed federal agency regulations or guidance. So there might be occasions where a certain federal agency is going to issue a new guidance or is going to issue a new regulation and it implicates access for language communities. That is an opportunity as well, maybe individually or as a group. Those are usually done with notice. They put notice usually in something called the Federal Register, and you can see. But a lot of groups have done that, have engaged in that process where they say, oh, you're going to change this rule from this to this. Have you thought about the implications for individuals who communicate in other languages? There again, your expertise as an interpreter is so critical because they might not have thought about that perspective. They might not have, and they likely don't have your expertise to know, oh, that will have implications. Maybe we shouldn't use AI because there's no way to assess the credibility or quality or professionalism or competency of that interpretation, right? So comments on proposed regulations might be another avenue. But these are just kind of four general categories of low risk actions. And I've seen a lot of these already happen, but I just wanted to kind of break it down into a whole category. They have a lot of similar characteristics. Some of this is individual action, some of this is group action. All right, we're going to go to the next layer here, to the yellow light, which is moderate risk actions. What are some examples of this? Commenting on pending local and state legislation or rules. I'm going to give two recent examples, and I've kind of mentioned both of these already. But in Michigan, like I said, the Michigan Supreme Court was proposing an amendment to the court interpreter rule. And when I looked at who commented, I looked at the comments, I saw comments from NAGIT and other groups. And this amendment, just so you know the power of kind of commenting on proposed rule change. This amendment received support from 25 of the 26 commenters. Now, the final decision on the amendment has not been made public yet, but I just wanted to illustrate that's what can happen. A group like Najit and other groups and even individuals commented on the rule and were strongly supportive of the rule. And just if you're curious what the rule was to expand. Currently in Michigan, interpreters are not provided in all civil cases. Um, Only to people who have the ability, who don't have the ability to pay for an interpreter. So it's kind of an income-based test. The proposed amendment was to provide interpreters in all civil cases, no matter the person's income. So the advocacy groups and individuals, 25 out of 26, commented in support of that. That's one example about a pending rule. A pending legislation, I've talked about the Wisconsin example already, but Wisconsin proposed an official language law, and there were letters and people who publicly spoke at hearings about this law. Um, there were many individuals from many different groups, and there was a lot of groups that you're probably part of that sent letters opposing these actions and the proposed action, which it didn't take place yet, but the proposed action in this bill. Again, this bill has not passed both houses. It appears that the bill might not go anywhere from everything I'm seeing from the bill tracking I've looked at for this bill. So, okay, part one, comments on pending laws and rules. People do it. People have done it. I gave two examples from just the last 6 months. What are other opportunities at the moderate risk level? Well, for training and education, a lot of interpreters I've seen do this, right? They communicate for community members. Maybe it's for parents or as part of a community group where you're providing training or education. Maybe it's for professionals. I remember a very long time ago when I was just starting as an attorney, I had a training for attorneys on how to work with interpreters. Well, one of the co-trainers, well, actually, there's two co-trainers, were sign interpreters, right? Sign interpreters not serving in the role of providing sign language interpreter services for the audience, but they explained how important it was during an interaction with a client, how to work with an interpreter, how to make sure that, and in that one, it was making sure that the interpreter was legally certified, had the legal specialty. But i- interpreters are part of training and education for doctors, for teachers, for attorneys, for judges. That's really important. You bring such an expertise to those settings, and you can really help those professionals understand what it means in those settings, the value of your profession in those settings, and why there needs to be interpreters and more effective communication in those settings. For educational institutions, I've seen the one example I'm thinking of is a state Supreme Court language access officer, and she used to give trainings at colleges and at a local community college. So training for educational institutions, going to maybe they have a master's of a certain language, right? And you go and you talk about your job as an interpreter, your role as an interpreter. At national or local conferences, we know this. The conference could be for interpreters and translators or just interpreters. Many of you, and I've seen these, do excellent presentations at these national conferences, explaining to other professionals a new topic, a new set of vocabulary that would be helpful to know, new issues you're encountering. These are the exact moments where you could talk about improving access to services, or we can gather ideas or support for different approaches to improve access. So these are all in the moderate. Why are they in the moderate? Because you are out there, right? You are the one giving the training. It's you. They see you. You're the one giving the comments in person, like if you're testifying. Um, you might be the one that sends a letter on your own. That's why they're more on the moderate risk side, because it's about more than just in the low risk as part of a group. It's you out there. So I put these in the moderate risk category. And I know you can probably think of a lot of other examples that you've actually probably done in your work or in your profession over the years. And the last example, I know people want me to get to this one, the higher risk one. What are these higher risk escalated actions? Well, these are legal actions. This could be a legal action with a civil rights group or an attorney. So when should these be options? These should only be options if prior lower risk advocacy efforts have failed or were unsuccessful. So you tried the low risk, you tried the moderate. It's very unlikely that in this situation, the case will be brought on behalf of a community group or a group of people. Um, So in this situation, it's not like it's going to be your case. It'll probably be a case if it is litigation on behalf of, Haitian Creole speakers in Southern Florida, let's say, right? It probably won't be your name on it, but maybe you had a role in helping identify the issues. So it is a higher risk. Legal actions may be an option also if you've been subject to retaliation, right? And like I said before, retaliation means that after you took part in a protected activity, and one of the examples based on what we're talking about today of a protected activity is filing a civil rights complaint or raising civil rights issues. So if you've taken part in that protected activity, some entity that knew you took part in that activity took adverse action against you because of that protected activity. That could be the basis for a retaliation matter. And the example I'm thinking of specifically is about an interpreter. They thought their court wasn't providing interpreters like they should. They filed a complaint with a federal agency, and in response to that, they alleged to the same federal agency that they were retaliated against. There was a full investigation. The federal agency determined that there was retaliation. The agency determined there was retaliation, which is an intentional violation of Title VI of the Civil Rights Act of 1964. And to resolve the allegations and the finding of retaliation, the entity had to pay the federal agency a payment that went to the individual who alleged the retaliation. So that is a higher level. That's why I say this is higher risk. It happens, these higher risk actions are when lower risk actions are not effective, when they didn't have results, or when these are really the only options available, a legal action or an action with an attorney. Or, which I'm going to get to next, it's necessary for your own self-protection, like in a retaliation matter. So last topic before we open the questions is self-protection. Not all these actions are high risk, right? There's the lower, there's the moderate, but it's really important to understand and just to re-emphasize when we're talking about self-protection, what I'm talking about are these four things. How to avoid conflicts. Remember, there are different ethical advocacy actions you can take during and outside the encounter, right? It's a fundamental principle of any interpreter code, avoiding conflicts of interest. So there are things that you can and cannot do during and outside the encounter. That's important to remember, just to reemphasize what I said before. Documentation is really important. Record incidents that you encounter. I'm not saying you're copying the medical records and all the specific information of the person that you where you saw the where the experience happened, but save copies of any related debt records or notes. Document the actions you have taken, including the date, time, place. Who'd you communicate with? How'd you communicate with them? What was their response? It's very important to have documentation, especially if either individually or collectively with a group, you're going to be documenting actions that are going to be part of an advocacy letter or a meeting with an entity. Know your rights. You have civil rights protections. And it's very important to know what those are. At the state level or at the local level, you might have retaliation protections as a contractor or as an employee. There might be whistleblower protections if you are in a workplace, or even if you're in a contract, there might be specific protections in that contract. There also are, if you're an employee, employment discrimination protections. And as we talked about before, there are ethical boundaries when you can and cannot ask. So know your rights. Your rights are just not limited to for that encounter. Independent of your profession, you have a right as an employee, as a contractor. Know what those rights are so you know when you can exercise them. And then when to seek legal advice, because you may need to seek legal advice if you're subject to retaliation. But I do want to get to questions. I know it was a lot. I appreciate all your attention.
Thank you so much, Michael. It is amazing every time we have you over. It's exactly what we needed. The clarity, the context, and the practical grounding that so many of us have been looking forward to get from someone since March of last year. So we do have quite a few questions. And I would like to start with the first one. What is the current status of lep.gov?
Oh boy, that's an easy one, huh? I shouldn't have. Did I mention? Oh yeah, I mentioned my bio about LEP.gov. So, it's my understanding that it has not gone up, and I don't have any indication that it will be going up.
Mhm.
What I will say is this, and I don't know if I put it on the resource document, but I can share it and we can send it in the follow-up notes. There are archived versions of LEP.gov that it's a little slow and a little clunky, but you can use it. I know some people are like, oh, I should have downloaded that resource or this thing or that thing. It works pretty well. So maybe I'll share that as a follow-up so people can have. I don't know. But I will say, going to the topic I was just talking about, I also haven't seen any groups in any advocacy efforts say, hey, we really need that site back up. So I think there's also just tying it back here might be a good advocacy opportunity. I know it's not just for the public, it helps a lot of professionals, it helps a lot of entities. Um, it was a lot of work to do that, and it was a real commitment by the federal government. I know a lot of people feel a great loss that it's not there right now.
Yes, I will definitely mention it to my policy work group that I'm on. Another question would be, are there any states that have bolstered their language access laws
Sure. Top of my
that you
head,
know of?
yeah, the best example I could think of is Washington State. I think on March 29th, the governor of Washington State, who used to be the attorney general, he he signed a law, and the law, I'm going to get this wrong. Someone from Washington State's going to correct me, but the law requires states to come up with uniform approaches um, for how they develop their language access policies and procedures. So statewide, state agencies to make sure that there's kind of a template that they use, so they're making sure that they're addressing. I could do with that in the follow-up too, Liliana, if you remind me. I'll
Mhm.
make sure.
Yes.
It might be on the resource document, and maybe not. But maybe someone can check that and see.
Yeah, feel free to send it to us. We'll send it to our participants. Um, Number four, I don't want to waste your time because if anyone is just like me, I want to ask all the questions and I want to get all my answers while Michael is in front of us. You mentioned compliance with Title VI is still required by state and local governments. How about non-government recipients of federal funding?
Yeah, so quick thing. So whether you are a state or local government or a government agency or a non-government agency like a nonprofit, if you receive federal financial assistance, you are always required to comply with Title VI of the Civil Rights Act 1964. Nonprofits are not exempt. The only way you're exempt from complying with Title VI is if you don't receive any federal financial assistance. And federal financial assistance has a very broad definition that includes beyond grants. It includes training and different agreements, and you might be a subrecipient of a grant from a state agency. So a lot of times people get confused about this, but nonprofit status does not mean you're exempt from compliance with Title VI.
Good to know. Um, Can you examine Title VI of the Civil Rights Act and its application to state DMVs in terms of language access, the lost prohibition of discrimination based on national origin? I'm thinking especially about Florida's new policy, which you also mentioned here.
Yeah, so real quick example. That case has already happened. So in people might not know this, but in Indiana, a lawsuit was brought by the ACLU against the Indiana DMV office. And in that case, that federal court said that failing to provide translated materials could establish a Title VI claim of intentional discrimination. Now, the case didn't go all the way through till decision, but there was a settlement agreement with Indiana and the ACLU to the ACLU's credit for bringing that case, and they reverse their policy and they will provide those. So it's already happened. There's already a court's already addressed that issue in a very similar circumstance.
Another one, how does the executive order affect educational interpreters, if at all, and the professionalization of educational interpreters and getting the Department of Education on board?
Well, the thing is, the executive order will affect the Department of Education because the Department of Education is a federal agency. So there will be things that the Department of Education will do in response to that executive order. There's nothing in the order that talks about interpreters. There's nothing in the order that can change Title VI. So, to the extent you've got a school district anywhere in the country that's receiving federal funds, they still have to comply with Title VI. So, no executive order can change that. policy decisions that a federal agency is going to make, those are going to be influenced by the executive order. They are. And just to give other examples, other federal agencies have already, in response to that executive order, taken down translated materials. LEP.gov got taken down, right? So we already have examples where, but we can't control that. We can establish good, rigorous standards for competent professional interpreters, no matter the setting, though. That's not prohibited by any law.
Mm. To piggyback on educational, any guidance on how to advocate for equitable language access within one's institution of employment, for example, interpreters employed by a public school district?
Well, I think and this will go in my trying to think low to moderate risk, not the high risk. Moderate would be who is the national group that you're part of, interpreter wise, or maybe state wise. Like you don't have to be out there with your name on the letter. Maybe you can have them help you craft a letter on behalf of XYZ association. We see these concerns. We really need you to address these concerns. We think that there might be civil rights violations both under state law and federal law, right? That's a lot of what you can do. I know there's a lot of hesitation, but yeah.
Another participant is concerned because how do we still comply with the law, also in education, while not receiving enough funds to provide language access services? We started using AI.
Yeah. Well, the thing is, and this is really important, but when Congress, passed Title VI and it was signed in 1964, there's no part of Title VI that says you do not engage in race, color, or national origin if it costs too much money, right? It doesn't say like you're prohibited from race discrimination unless it costs you a lot to desegregate, then you can't. There's not a get out of jail free card because it costs money. Everything's going to cost money. Think of the risk that's involved, right? For like misdiagnosis, parents not understanding the IAP meeting. I mean, those risks weigh far more than any cost. This is always an issue. It's not an either or thing. Maybe they do have a way that they're going to effectively use AI that's been vetted to make sure the AI works the right way, but it doesn't mean that it takes away anyone's rights. And cost, and DOJ said this in a letter to courts in 2010, cost is not an excuse for complying with civil rights laws. And we know that in the ADA too. The ADA has lots of protections that are similar to the language access protections, and you can raise costs, but you have to prove that it's really going to cause an undue burden. And almost every case I've seen, the entity is not able to establish it's going to cause an undue burden.
To change the topic quickly, we have 2 more minutes
Yeah.
that Mike is with us. In regards to rollback of DEI policy at federal level, is the EO 14224 part of the rollback of DEI policies?
Well, from my understanding, and this is just based on the court cases that have happened in the last 6 months, Um, the most significant DEI policy change was a letter that the U.S. Department of Education sent to all school districts and all kind of educational institutions. That letter has been revoked. Federal court said that you can't, and this is what they said. Federal court said the federal government cannot use an executive order to create or change existing civil rights. So all those things about DEI from the Department of Education have been revoked. Those are not requirements anymore. The Executive Order 14224 is not part of that umbrella, but it's an executive order like any other. It has no authority to change laws or regulations, unless there's notice and comment and they follow the right regulatory process, unless Congress passes a new law. But I will tell you this, there's no law that says DEI is illegal, and that's not Title VI.
Another participant says HUD has eliminated its Title VI language access guidance. Unlike other sectors, there are no other laws to direct how language access is to be provided. In fact, language access has been characterized as DEI activity that results in equal treatment of people, which would be illegal. Do you have any thoughts on this and how providers of federally assisted housing should
Sure.
address a need for language assistance?
Well, the case I'm thinking of is Cabrera v. Alvarez. It's a case from, I think, the Eastern District of California. And in that case, it was about housing and public housing. And the court said that failure to provide language services in a public housing setting can establish a Title VI intentional discrimination claim. So I don't need the guidance for that. A federal court's already decided that that could be a form of national origin discrimination under Title VI. Guidance is not law. So removing the guidance doesn't change Title VI. Having the guidance doesn't change Title VI. I know the guidance was helpful, but it's not the equivalent of a law or a regulation.
Okay. I have one more question. This one is a personal one. It's from me. Um,
Okay.
You have spent your career on the enforcement side. Now that you're consulting for public and private entities, you're pretty much sitting across the table from people who you used to investigate. What are organizations getting dangerously wrong about their language access obligations right now? And what would it take for a complaint to land on a desk like yours used to be?
Um, Things that they're getting dangerously wrong. I think the confusion about the executive order, that 14224, is causing
Mhm.
people a lot of problems. I know I spent a lot of time at the beginning, but I think that's a key one. Um, there are certain things, though, that entities can, practices they can engage in, that no matter who's looking at it, I'm not talking about any political party, but no matter who's looking at it in the federal government, is intentional, right? Like there's no other way to conclude what's going on here. It wasn't a one-off mistake. It's a series of practices targeting certain language groups. You know it's going to cause harm and you keep on doing it. That to me rises to a level of intentional discrimination sometimes. So no matter who's looking at the complaint, the problem is, I don't know that anyone's going to be looking at complaints in general on the federal level. And that's the real challenge. But that's why we have state and local advocacy. That's why we have state and local offices that can address these issues.
Yeah, we are definitely going through a transition. We just have to keep our, hope and that more people like you, more people like our participants whose job is not just a job, it's a calling, and they want to do the right thing and they want to be there for their communities and their patients and their um, clients. So, do you have any more time, or are we done with questions and we have to
I
say bye to
I
our
do, but I don't want to. I know people, probably scheduled 11:30 to 12:30, so Eastern time. I know, but I want to be respectful of that. But I could probably do like probably like
one
10
more?
more minutes.
Okay, perfect.
But
So,
I don't
there's
want to.
another.
But if people have to go, like, don't feel any obligation. I can do 10 more minutes. So
Yeah, there's no issue. Anyone who wants to log off, your certificate will arrive. Do not worry about it. This is totally optional. Stay, go, get back to your afternoon, whatever works for you. But we will stay a couple more minutes and we'll answer a few more questions now that we can. So, another question would be, I'm not an interpreter, but social worker. I joined an agency that has been using a family member to interpret meetings with a client for 2 years. I informed my leadership of ethical concerns.
mm,
How should I proceed with bringing access to programs to this client, particularly who speaks Arabic?
yeah, this happens a lot. I mean, this happens in formal settings, right? I mean, this still happens in medical settings sometimes. Um, I think that having raised the ethical concerns is really important to do because professionally, it's uncomfortable to see this happening. There's a lot of fact-specific things for this particular situation, right? Like, what entity are we talking about? What setting are we talking about? Does the entity receive federal funds? Is it in a state where there's language access laws? So I think there's a lot of specifics here. But I think um, um, I would not focus on this client particularly who speaks Arabic. Like I said, ethically, I think that's going to get you in trouble. I think it'd be far better to say, hey, where are our language access policies now? And a lot of times there are no language access policies. So maybe this is an example you can use, but I would not kind of just do it as advocacy for that person. Maybe it's an opportunity. I know this is interesting to frame it like this. Maybe it's an opportunity to have a conversation they've not had about how do we provide language services. You, as the interpreter, can be the real educator on here are good policies, here are how to do it. You can really help guide them. And maybe it's not wake up tomorrow and everything's perfect, but I think your knowledge and expertise can really guide them the right way to establish better policies and not just focus on this person, what can I do to fix it right now?
Um, a lot of information, a lot to process. And for the ones who are new to this, bear with us. It took us a long time. I speak personally until I figured out everything that's going on, and I still don't know half of it, but um, it's the intention that matters. Another question. If they only offer VRI or OPI, is that being compliant with language access? If they use AI, is that being compliant?
Well, the thing is, um, the obligation is to provide meaningful access, right? So I'll give you an example, two examples of the same situation with video remote. And this is just from my own exposure, which was somewhat years ago, the last time I used a VRI. If the connection quality is poor, right? There's no ability to appreciate nonverbal communication. The audio is breaking up. I don't think there's anyone that's going to say that it's a meaningful opportunity. As a product, it could be, right? If it's got a strong connection, and if you look at the ADA regulations on this, right, they specifically say like strong connection, can see the individual, can see the interpreter. There are both ways on that. It's really about the quality. If it's consistently bad, you might have a bigger issue. I know some people are really kind of fascinated and like the idea of like, oh, look, it's a portable thing on wheels. Okay, have you tested the strength of the Wi-Fi as it goes through? Because guess what? In a lot of these buildings, they're concrete and there's concrete walls. That's not a very good signal. So there's a lot of things on the, did we test this before we rolled it out? I'm finding with both, even with VRI when it first came out back in the day and AI now, that's kind of shoot, aim, like you need to test it first. And I don't think people are still thinking of, oh, maybe we should do user testing. Maybe we should test this in the basement, on the second floor, three building, really test it in real settings, then see if it works. Don't fall for, and I say fall for, uh, let's see advertising or promises in whatever number of languages. Try it in your setting before you buy it and use it day to day. That's what I would say.
Mhm. Very important. Even I think there's no research right now that can confirm that, but definitely try to make a difference and raise awareness as an interpreter. What Michael was saying earlier, we have the expertise. Some of these people who make the laws are not interpreters. They do not know how to see language in the same way we do, how to see language access. So it is important for us to step up and make the difference. Another question would be, I lost it. Are school districts required to provide translation and interpretation services to families, or just one of the two?
So, this is really important, and I know it happens a lot, but one of the most important Title VI cases was a case about a school district. And it was called Lau v. Nichols, and it was a Supreme Court decision.
Mhm.
And based on that decision, it covers the range of needs, right? So I don't like to limit it to just interpretation translation. Maybe there's other needs, but generally, yes. It's been around for 53 years. It's never been overturned. And that obligation specifically, that case was specifically about a public school district. Um, there is no better case to look at what happens when you don't provide those services and the impact it can have on children. So, yeah, that's very long-standing. There are many other laws. There's the Equal Education Opportunities Act, which also talks about the obligation to provide bilingual materials and services. There's lots of other regulations in the special education context that talk about this. They don't just talk about one or the other. Almost everything that I've seen addresses the two general categories, interpretation and translation. And even if all those don't, Title VI addresses kind of meaningful access by a entity receiving federal funds, and that includes both interpretation and translation. So there's a lot of overlapping coverage points for a school if it receives federal financial assistance, and there are very few schools that don't.
Another question related to this one. If they close the Office of English Language Access at the Department of Education, how would this affect us at state level?
I mean, they have closed that office in effect, but closing a federal agency office does not change the laws that that state and those local school districts have to comply with. I mean, they can close the disability rights section of the Civil Rights Division, but it doesn't make the ADA go away. It doesn't make Section 504 go away, right? So the EEOA is still there. I'm going to that specific question. Title VI is still there. Unless and until Congress takes action to take away those laws are still applicable. Now, maybe it's helpful to have those federal offices to help guide them and direct them and make sure they're complying, but they have an obligation independent of who's guiding them or if those offices are there or not.
Is anyone else as excited when Michael says, again, this does not delete the Title VI of Civil Rights. This does not change. I think it's really important to hear that over and over again, that all of these attempts to diminish and to dismantle are really not getting there yet. So another question would be, who do I contact regarding state language access guidelines that say the most qualified interpreter must be hired, but the courts, funded by county commissioners, insist on the lowest price interpreter. The most minimum of guidelines have has been instituted in South Dakota, including a state language access coordinator who is simply a designation of someone who doesn't really do much.
Yeah. I mean, I'm very familiar with South Dakota. It was one of the investigations I did.
Cool.
But yeah, what I would say is that, one of the best ways to get at, especially in a court setting, if we're talking about state courts, it really is about making sure that on the administrative side, on the state court leadership, like the state court administrator knows about these concerns, but also you have recommendations of what can be approved, right? Like we don't have a code of ethics. We don't have a guidelines for judges on what they should do. We don't have a guideline for judges on who to choose as far as interpreters. Maybe there should be a court rule that says in every encounter, if it's determined an interpreter is needed, the judge must first pick this type, then this type, then this type. And I've seen that happen in other states where they have more detailed rules about who should be the first choice for an interpreter.
And doesn't closing these offices and not having anyone to enforce regulations send a message that these guidelines aren't important and don't need to be followed?
It might send that message, but that's not correct. So it is meant to lead people to believe that these protections and these rights don't matter anymore. Now, you have a choice. You can agree with that, but if you agree with that, you have to understand that none of those protections went away. So you can agree with that, and that might be, what I called confusion, but I would not fall for that line of reasoning, is what I would say. That is the approach that's being taken. That is what meant to mean for people to believe that their rights have been diminished. There's been no change in the right. Now, there's not offices out there enforcing those rights for people, so other offices need to step up. That's why I'm really focusing on the state and local. There are opportunities that state and local entities are taking, saying, if you don't want to do your responsibility, we're more than happy to do it, or we'll do it in our own way for our own communities. And just like interpreters can, if there aren't people that are going to be enforce it, we're going to raise these issues. We're going to advocate. We're going to take action.
Switching to healthcare, we have a couple more minutes. There's a health care company, I assume, in California that works with Medicaid California, that has decided starting January 2026 not to pay interpreters when we show up to an assignment and the patient is a no-show. That has caused a shortage in interpreter coverage. Is that kind of a measure a covert way of not complying with language access on the insurance side?
Um, I've seen that issue. I will tell you that for me, that is, if we're going to categorize things, I would categorize that as professional concerns professional interpreters should raise with the entity, different than rights of access that people have when they're trying to access those. So I put that more in that is exactly the kind of conversation that a professional association of medical interpreters or generally interpreters could have with a state agency about, hey, there was this policy change. But I would not put that in the category of like Title VI or civil rights protections. That's more on the us as professionals. We're seeing this happen and it's impacting us as professionals. You can mention we also feel it has this overflow effect of taking away people's rights because they don't have interpreters. But the example that this person gave, the person didn't show up, so they weren't denied an interpreter, right? The person was a no-show. So I would categorize that as the work conditions, quality of work, professional concerns that an interpreter group could raise with a state agency. And I've seen that happen. I'll tell you, in other states I've worked in, this one state I'm thinking of, the Professional Interpreters Association did just that. Like, you want to change that policy, fine, but this is the impact, and we're not going to be supportive of it. And they let the agency know. And I don't think those changes went through because of that advocacy.
Another question, in the moderate risk actions category, when it comes to training and education, what risk would someone run by being seen out there? I had not thought of presenting at a conference or facilitating a training on language access as posing any risk.
Well, I mean, the conference example, the thing about the conference example specifically is unless the very entity or the director of the entity is at that conference, it's very, I mean, look, I love ATA conferences and NAGIC conferences, but I find it very unlikely they're going to be sitting there at that presentation. The other thing
Mhm.
is, because you're all professionals, I doubt that you're going to say, for example, this guy in this, so I don't think there's a lot of concern in that kind of setting because you're not going to talk about specific incidents. You're not going to talk about specific people that you interpreted for. You're not going to shout out a particular agency or entity. So I don't really think there's a lot of risk, and it's very unlikely that someone from that. But even if they did show up, I think it's really important to say, how could I frame this in a way that does not identify? a person or information I shouldn't be disclosing, and still get my point across. I think there's ways to do presentations, and not disclose that. I have to constantly think about that though when I'm doing my work, even these days, about I don't want to mention X state or Y county, right? But I can still make the point about what they did or did not do. So I think you run less risk if you kind of anonymize as best as you can, without those details.
Or another way to see it, what would Michael Mulé do
Well, I don't know
or
about
say?
that. I don't know about that. I might say things that
Always
you
when
would
you have
not
an
feel
issue.
comfortable saying, but but yeah. Okay,
Michael, thank you.
sure.
It's 12:46 now. Thank you for everything, but thank you for 20 years of work that has kept language access moving forward and for spending this hour with our community today. We definitely hope you will come back. A lot of people in the comments are thrilled that you were here, and they definitely want you back as a regular every other month. You give us the updates of what's going on. So everyone is really, really excited that we had you over. Thank you so much. And we're gonna let you go now so you can enjoy the rest of your day. We appreciate you. We appreciate all of your knowledge that you shared with us today and your time and for making this part of your calling, right?
Well, thanks for having me. I appreciate the opportunity. Everyone take care, and maybe we'll see you again soon.
Perfect. Thank you, Mike.
Cuídate.
Yeah. Hasta luego.
Ciao.
Um, I also wanted to say a warm thank you to Madison and Jenna, our ASL interpreters, for their work throughout the session. We will definitely stay for another few minutes if anyone has other questions in the chat for CCC. One last reminder, your certificate email is coming within 48 hours, more or less. Check that spam folder. Download it within 3 weeks, add your name, and you're all set. And thank you so much for being here today. Thank you for being with us.